I want to talk today about 5 mistakes that people typically make when trying to handle a long-term disability benefit claim, a life insurance claim, pension claim, or a retirement claim, and sometimes even medical benefit claims when they're larger claims. I'm going to talk first of all about this very first mistake, and that is representing yourself. Now, we've all heard the joke that a lawyer who represents himself or herself has a fool for a client. And the reason for that is varied, but one of those reasons is that you lose your objectivity and you're not best able to ascertain how to proceed. Well, that's a generalization, and a lot of times people say, well, you're just trying to get the business to help people. And, I might be able to handle my claim for myself and save those attorney's fees. That's one way to look at it, but that's not where I'm coming from. Where I'm coming from is actually looking at the circumstance and answering about 7 questions. And answering those questions truthfully will help you analyze whether you should obtain an experienced ERISA attorney in connection with your claim. First of all, very first question, is your claim important to you? How important is it to you? Does it involve money that you critically need in order to survive? You have to answer that question as to analyzing how important it is to have representation. Second, do you handle these type claims every day? The insurer or the plan administrator who is denying your claim handles these type claims every day, and they deny them every day. Many people have this illusion that if I'm nice and I'm just honest, then they will pay the claim. That's not how it works. There are always a few people out there with fraudulent claims, but the majority of the people making claims for various benefits that they're due to receive honestly should be getting those benefits. I have yet to represent anyone who is making any type of claim that I did not find to be well-based. And I've been doing this since 1992. The third question, are there future issues involving my claim that I don't know about but need to be considered now? A lot of times what you do and what you say in the earlier part of the claim process has an effect later on, and you need to know all of the ins and outs of that claim process. What you do now could have a bad taste later on in connection with the claim. It may hurt your claim. Question 4, do I know the law well? A lot of people don't want to take the law into account when handling a claim for their own self. You have to take the law into account. Ignorance of the law is no excuse. Courts will not cut you some slack just because you handled your claim yourself. They will hold you to the legal standard applicable. They will hold you to the precedent that is out there that might be impacting your claim. So you do need to know the law well. Fifth question, do I know what strategy to use with my claim? You better. These claims follow a very specific claim process that's found both in plan documents and in the claim procedure regulation. The claim procedure regulation sets the floor or the minimum standards and then the plan document may impose things on top of that floor. You need to know what strategy to use in connection with that process. Some of that strategy involves knowing what documents to obtain, knowing what evidence to submit, knowing what evidence to counter as far as what the insurer already has. Next question, is it possible I will hurt or ruin my claim? If you don't do things right with the claim process, you can cause your claim to become worthless. That's something to seriously consider. And the last question, would it be better to have most of my benefit rather than losing all of my benefit? Yes, a lawyer has to charge you something in order to perform services for you. And that charge may be an hourly fee, or that charge, which for most of our cases is a contingency fee, where we obtain a percentage of a benefit. And in charging that contingency fee, we have to take into account the labor required, the level of difficulty of the claim, liability issues, a number of different matters. And in charging that fee, a lot of clients wish we didn't have to charge anything at all. But of course, we wouldn't stay in business if we did not do that. So you have to answer that question honestly. Would I be better off at least having most of my benefit instead of all of it? I hope these 7 questions help you in making a decision as to whether you should obtain experienced ERISA counsel in connection with your long-term disability claim, your life insurance claim, your pension or retirement claim, or your large medical benefits claim.